Welcome to Business Talk with Megan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Megan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way. So I'm here today with Ray Barcelo, and we're going to talk about intellectual property law. And Ray, how are you doing today?
Doing great. Nice to talk to you today, Megan.
Nice to talk to you as well. So a lot of business owners don't necessarily know what basically the extent of when they come up with ideas or have devices such as a medical device, what they need to do in terms of hiring an intellectual property attorney and how that works. So I was hoping you could explain the basics of intellectual property law and how it protects various types of IP, such as patents, trademarks, copyrights, etc.
Sure. I mean, we can talk for a long time about all that, but basically hundreds of years ago, people were fighting over real property, parcels of land and countries and things like that, and we still are. But now the battleground has shifted to intellectual property, which is the world of ideas. If you think about like an old medieval village, they might have a sign above a shoemaker's store with a certain logo on it, and that was done a long time ago. And that's where trademarks come in. So trademarks are the things that deal with the name or a logo of a company or a product. You might think of it that way. The focus is on making sure there's no confusion about where goods or services come from. Those are trademarks. That's one kind of intellectual property. Another one that people know about or hear about all the time are copyrights. If you write a book or a script for a movie or take some really cool photographs or even have a sculpture or some architecture, that's the world of copyrights. And the touchstone there is to make sure that people don't rip off your expression, not necessarily your idea that you say, well, I'm going to have a book about goblins and witches. That's not really something that would be copyrightable, but the way you write it, the language you use and the names of the characters and all that, that's what copyright is all about. Then we get into probably the most sophisticated aspect of intellectual property, which are patents. And those are basically the ideas about making a new widget, making a new product or a method that's never been done before to solve a problem, like a new kind of light bulb in the case of Edison or television or stuff on the internet. And then there's a few other types of intellectual property that we can get into, but people confuse them all the time.
Right. It's a complicated matter. And I guess that kind of brings me to like what misconceptions or myths are there about intellectual property that people should be aware of?
Well, one thing that people do is they use the wrong label when they're talking about intellectual property. They say, well, I want to copyright my company name, which really what they're talking about is trademarking it. Or they'll say, I want to patent this book that I just wrote, where they should be talking about copyright. But that's okay. That's easily sorted out. So what actually happens in intellectual property is there's all these hidden rules and laws that could bite you and basically affect your rights negatively if you don't have a good lawyer to guide you through it, or if you don't really understand the concept. So for example, if you have an idea for a new toy and you think it should be patented, and if you actually go and start selling it before you file a patent application, there's a limited amount of time before you can do that. And if you wait too long, then you're barred. It means nobody can ever get a patent issued on that idea if you wait too long. So there's gotchas like that all the time.
Yeah, that's interesting, especially if you start a business, pick a name for the business, and then someone says, nope, I already have that name, and they come after you. Can they do that? So if I wanted to call my business, I don't know, Chandelier.
and someone else was registered chandelier in Newport Beach, could they come after me and say, sorry, you just stole my name and my business?
So there's so many layers to that, but actually the example you gave is a good one. The first question we need to ask is, what's the business for? Because if it was for a business for some kind of lamp or actual chandeliers, then that name would actually be descriptive of what you're selling. And there's rules about that. And you probably could not trademark that or go after anybody for using that, because it's too obvious that if you go to a lamp shop that's called chandelier, that's what it's for. So there's really nothing unique about it. Now, if you have an ice cream store called Chandelier or a woman's stiletto store called Chandelier, that gets to be more interesting, because it's not descriptive of what you're selling there. It's more fanciful or suggestive. And so that gets into a more interesting and possibly more trademarkable kind of situation.
I see. Okay. What are the benefits of registering intellectual property? What are other benefits if people are like on the fence about it? They kind of get lazy and decide maybe I don't need to.
So benefits are if people are using similar names or similar ideas or similar expression as what you have. If you don't register, if you don't formally go out and get the government's seal of approval that this was looked at and that it actually is intellectual property, and they give you a number and a registration for whatever it is. If you don't have that, then it's harder to go after people in court. And even if you do, the amount of money that you can get in a recovery, it's limited if you don't, or non-existent if you don't register it. So that's one reason. Another reason is many times people, as most business people know, even when there are disputes, most of them don't even get to court. You get all these letters. People all know about cease and desist letters flying back and forth. Mm-hmm. And it's much more persuasive and frankly scary to send a letter that relates to actual registered intellectual property, as opposed to some concept that people feel is something that's protectable, but they never bothered to register it or get it granted by the patent office.
What's the process or timeline for obtaining a patent or a trademark or, I guess, copyright registration?
Okay, let's start with copyright.
Okay.
So copyright, the right basically comes into being the moment somebody affixes that on a tangible medium. So that means if I go to a lunch and I make a little picture on a napkin and I sign my name on it and I put that little C with a circle on it in the year, that's automatically copyright protected. It's not registered, but the right ensues as soon as you make it and put it. We can't just be talking like we are now. It's got to be recorded. Like I think this is being recorded for a podcast, so that would qualify. What we're doing right now is actually a copyrighted broadcast or podcast, and because it's being recorded. And so the right comes into being right when you basically record it someplace, whether it's a piece of paper or some magnetic or electronic device. But you cannot go to the copyright office and get it formally registered. So that's how you get, and that might take a few months, but the actual right is instantaneous. So people talk about mailing things to themselves and never opening it. You can do that kind of thing, but it's rarely necessary.
Okay.
When we're talking about trademarks, let's say you wanted to start, I don't know, a women's shoe store like we talked about a minute ago. The minute you start offering shoes with your name, let's say you are going to call them chandeliers, Megan's chandelier shoes. The minute you start offering goods or services with that name, your trademark rights accrue. They come into being. You don't have to do anything. And you can say, now I have a protectable trademark. We don't know if anybody else is using it or if anybody has a competing right, but your trademark right comes into being from use of that name. And then you can go and register it. And the first thing they ask you at the trademark office when you try to file a patent trademark application is, well, when did you start using it? Because like I said, the right accrues when you use it. Patents are different. Patents, the right comes into being basically when you get a patent granted by the patent office of the country you're in. So we're in the United States, so let's talk about U.S. patent law. So like I said, you have a limited amount of time from when you start selling your idea or offering it for sale or publishing, information about it. You basically, generally speaking, you have a year to file a patent application, and then it might take several years before the patent office looks at it and does something called an examination to it, which means comparing what you're claiming as your invention versus the body of what's already been known, which is, vast, to make sure that there's nothing out there that's either the same as what your invention is, or even if it's different, that it wouldn't be obvious in view of what people already know.
Very interesting. Can you share any notable cases involving intellectual property that you have worked on, or that business owners would be potentially interested in hearing about?
Sure. A lot of my ideas have to, I'm an electrical engineer, so I deal with computers and electronics and internet and some high tech, kind of very important, but also kind of nerdy and not fun to talk about stuff. But once in a while, I do get to talk about really interesting ideas. So I have a client that's in the video game space, and they came out with a lot of inventions having to do with virtual reality. So I help them get a lot of patents in that field, as well as fight other people's patent assertions against them many times. But probably the funnest thing I ever worked on was I had somebody come to me one time and she said, "Do you know what décolletage is?" And I did not know what that word means, but I think most women know what that is. And that's basically the region in a woman's neck, like below her chin.
Okay, yes.
Some people, and I said, "I don't know what that is." And she says, "Well, did you know that women that sleep on their side, they get these wrinkles in that area, and that as they age, it kind of becomes unsightly, and many people don't want that." And she said, I discovered that what happens is when women sleep on their side, one of her breasts basically flops onto the other one, and those wrinkles. And I discovered a way so that wouldn't happen. And basically what it is it was kind of crude at the time. It was a prototype, but she said, the way I solve the problem, my invention is basically this thing where a woman sleeps with almost like a water balloon between her breasts. And that's the idea. And I looked it up, and lo and behold, this problem had been known since at least the 1920s, if not earlier. And there are many inventions for that. But over several years of working with this woman on her team, she refined the idea. So it became like a sleep bra that was made out of this material, almost like a wetsuit, almost like a surfer or a diver's wetsuit that had more material kind of in the middle of the cleavage area. And then she was able to patent that. So like I said, that was kind of a fun, unusual tech patent that I worked on, and helped really get some patent rights on that.
That's really neat. I think I've seen something like that. You sleep with it on, and then it prevents the wrinkles from happening. That's
exactly what it's all about. So yeah, so once in a while I get to work on maybe some cocktail party worthy kind of invention.
Yes, I love that. That's a good one. Okay.
And also, last week, I should toot my own horn a little bit. Time magazine, every year they come out with something called Inventions of the Year, and actually last week's issue was about that. And a client that I had a few years ago, they had their invention listed there last week as one of Time Magazine's Invention of the Year for this year, for 2023. And what it's for people who are deaf or hard of hearing, so they can still experience music. And the way it works is it's a vest. I don't know why I'm talking about vests so much today, but it's a vest that you put on, and these wristbands and these ankle bands. And basically there's vibrations, like if you were working with your Xbox controller or something, how it shakes, or how your phone vibrates when you get a call. This vest would vibrate basically to the beat of the music. So if you were at a concert in Central Park, which they did, and several people were wearing these vests, whenever there would be a drum beat or something, then the vibrations in your stomach or your back, you would feel that. Or if there was a high note on a flute or something like that, then you would feel like this fluttering kind of sensation, maybe on your collarbone and things like that. So you can basically feel the whole band or the whole orchestra on your body. And that invention got Invention of the Year last week. So we were excited about that.
That's amazing. Did you go to Viterbi Engineering School at USC?
Yeah, I was just there yesterday for a homecoming event.
Oh, you were? Okay. I graduated from that engineering school as well, but I'm not going to homecoming yet. Tomorrow is the football game, but yes. Mm-hmm. Are you going to go to the football game?
No, I have another event with my high school kid. He's got another football game. Basically.
Fun. What are the options available for enforcing intellectual property rights if someone infringes upon them?
So it depends on what kind of right we're talking about, and frankly, how much money is at stake. Let's say somebody's using your name that you have for your business or for your products or something very similar. typically what will happen is you're going to want to get a good attorney who knows this field of law, and they'll evaluate the situation. And probably the first thing that'll happen is writing one of these cease and desist letters to the other side or their lawyers, basically telling them what you feel has been violated and why, and how how you have this right. Hopefully, it's a registered trademark, for example, and explaining the damages or the remedies, which are could be severe. It could be much more than what they're making from selling these, let's say, these knockoff products, and that they should stop. Otherwise, there's going to be litigation. And then many times, negotiation ensues, and usually there's an agreement or some kind of settlement. But if you can't reach an agreement, then whoever sent that letter needs to be basically ready to back it up by going to court and fighting for that. And that'll be pretty much expensive and take a long time. But that's basically how these things go.
Okay. What if you want IP rights in multiple countries? Is that possible? How do you do intellectual property protection work? How would someone protect their IP rights across multiple different, I guess?
Yeah,
nations?
so luckily 100 or 150 years ago, our forefathers had the idea to have these treaties. So there's international intellectual property treaties, so that if, let's say, you file a patent application in the US, within a year, you can file a patent application in other countries, and sometimes groups of countries, without losing the benefit of your original filing date in the first country you filed in, and that's called the Paris Convention. And so you can, and there's something called the PCT too, the Patent Cooperation Treaty. And so it gets a little complicated, but there are ways to extend your patent rights to other countries. It gets expensive to do a patent. Let's say you're a pharmaceutical company that invented a vaccine for COVID, so you really have a lot of money and you really want to get patent rights all over the world, which is what happens. To do that might cost you $500,000 to $1 million when you're just in attorney's fees worldwide to do that, and patent office fees. So it's not for everybody, and it's not for every invention, but there are ways to do that, and there's similar treaties for trademarks and copyrights.
Okay. Very nice. So I kind of want to switch to medical devices, since I used to work with two startup medical device companies and familiar with the field and scientists and engineers trying to bring their products to the market. So I guess my first question on that is, how do regulations such as HIPAA affect intellectual property rights of electronic medical devices? Is that ever an issue, the HIPAA law?
Yes, medical devices are very interesting because they involve a lot of engineering and a lot of medical kind of aspects, and they help a lot of people. So not only is the patent office involved, but the FDA is going to get involved, and there's clearances, the Food and Drug Administration. There's different clearances that people need to get just to be able to sell the product. So they're heavily regulated. So not only do you have to worry about patent protection, but you have to make sure that you meet all the regulatory requirements that the FDA might impose, depending on what kind of medical device it is. For example, years ago, I worked with pacemakers, which are devices that get put in your body to help your heart beat at the right rhythm. And those are heavily regulated because they're implantable devices that go inside your body. So they're very difficult to bring to market. And HIPAA will come into play into that. For example, in that case, HIPAA is a privacy kind of law. But in the case of pacemakers, there are databases where if you go to the doctor to have your pacemaker checked, whatever they do to tweak your pacemaker goes on this database that can be accessed by people who basically are authorized to do that. But if you get in a patent lawsuit about those pacemakers, you might have to, the other side might ask you to reveal those kind of databases, and that gets into a direct HIPAA violation. So that's an example of where that might come in, and it gets very complicated.
Is this an area that you focus on, the medical devices?
Yes, in particular, the ones that have electronic components.
Well, yeah, I would say very complicated, lots of regulation and potential for issues. Definitely need a lawyer.
Shortage of issues when it comes to medical devices, but they're very beneficial to mankind, and there's lots of startups and well-established companies that are always coming out with very interesting products, and that's one of the best things about our country and the world that we live in now, that there's so much innovation.
So much innovation. Can you provide any guidance for navigating the regulatory landscape with electronic devices that now lots of people, bad actors might be able to access, or even FDA approvals and compliance?
Well, hopefully the people at whatever company is doing this have, experience in navigating this regulations themselves. But even beyond what they know, they should really surround themselves with a team of intellectual property attorneys, regular FDA kind of regulatory attorneys, and frankly, maybe some lobbyists to make sure that the right laws get passed to help their company or their industry. And they should also belong to the right industry groups that are basically advocating for their kind of device industry that they're in.
So I have a kind of an interesting question about investors. So I don't know if you have an opinion on this, but how do you think intellectual property rights can be leveraged to attract investors, or securing funding, or negotiating licensing agreements? Do you have any opinions about that?
Yes, I do. Investors are keenly interested in intellectual property. In today's world, especially in the tech sector, the value of companies is driven by intellectual property. And so when you talk about the value of a company, whether it's some kind of exit strategy, whether it's selling a company or going public with it, any kind of event that basically monetizes the company, many times the value will get multiplied by some large number, three times, 5 times, 7 times, if you have strong patent protection for the products that you're offering. So it's hugely important to look after your intellectual property rights and protect them and get them registered and basically acknowledged as quickly as possible. And it's going to cost money, but at the end of the day, it's going to be very, very valuable when you're trying to exit or get your company valued or get investors involved.
So back when I was a medical device sales rep, I was selling a product that the company had the patent rights on it. I think I'm saying this correctly. And I was the sales rep for the company, so I was the only one allowed to sell it. And all of a sudden the patent was up, and my competitor decided they were going to start selling it. Like, how does that happen? Like, so as a salesperson, I'm like, oh my gosh, this is very annoying, because I want to be the only one selling it. I don't want my competitor now selling the same product I have. So I guess it's also like pharmaceuticals, where you can make the generic drugs, and some people are going to buy the generic because it's less expensive. But is there a way to prevent that if you're the company from having your patent run, fire, I guess?
In general, patent rights last around 20 years from when you file a patent application on your idea or your invention. Several decades ago, there were these techniques for kind of extending that time frame that especially pharmaceutical companies would use. And those are kind of loopholes, and over time they've been kind of closed. So it's pretty strict now that if you have an idea that's patented, the protection is only going to last you a limited amount of time, around 20 years.
Interesting.
And so what that does is that means if you are the patent owner and you want to maintain your market dominance, what you have to do is you have to reinvest the money that you're making from the fact that you're the patent owner and hopefully making more money than your competitors. You have to reinvest that money into research and development of the next generation of products and then patent that. And that's what drives innovation.
I like it. Okay. So there you go. That makes sense. I didn't pick up that the positive part on it is that it keeps making everyone get better and more competitive. So they're putting out better products.
You don't get better than your competitors will, and that's like your market share or your market position. So that's how competition works.
It's good. Okay. I like that. Do you know the shoe designer Christian Louboutin, who has the red soles on the bottom of the shoes?
Yeah.
So did he have to, if someone else wanted to make a shoe and put a red sole on the bottom, would they be potentially infringing on Christian Louboutin's shoe design? He probably patented, I'm sure, the red.
So I think that's the trademark, actually. I think he got trademarks on that. And as I recall, maybe design patents, which are a different kind of patent. We've been talking about utility patents today, which are for like the machines.
I know, I switched here.
We call it design patent, which is basically on the ornamental look and feel of it. And so that's why those kind of shoes, he's the only one that can make them with the red soles because they're trademarked and have a design patent on them.
So a lot of business owners who are starting companies with unique intellectual property, it's extremely important for them to have someone like you a part of their team, making sure all this is taken care of, because it's going to affect everything overall, the value of their company, how their sales team operates. And it's fascinating. I don't think a lot of people are aware of this, or maybe are intimidated by the process.
Yeah, it can be intimidating. It's complicated. It's multifaceted. What we say at my firm is that the intellectual property landscape is like a minefield. And basically our motto is we help you navigate that IP minefield. And you need an experienced attorney to do that, because there are so many different laws and variations and scenarios that it's not a do-it-yourself kind of thing. You need experienced professionals helping you every step of the way.
I've been asking everybody this lately. How do you feel about AI now, and the fact that we have all these computers somewhat doing legal work? I mean, they can't really do all the legal work. You still need humans. But do you have any thoughts on the AI and intellectual property space, artificial intelligence?
Yes, I'm involved in that a lot in terms of working on patents dealing with AI and using AI myself as a lawyer. And obviously we've heard kind of horror stories of lawyers basically not doing their homework, and instead of doing legal research, just trusting AI to come up with cases which end up being fake, that they cite to judges who then get upset about that. And obviously people shouldn't be doing that, but there are very appropriate ways to use AI to basically bounce ideas off and maybe help you get started on a research project, or point you in the direction of something, or maybe turn your writing into something more readable or persuasive, or maybe grammatical, if that's what the kind of problems that people have. So AI is a tool, just like a pencil is a tool and a computer is a tool, and it could be used properly or improperly.
Do you think that AI is going to take lawyer jobs away in the future, or do you still see we're going to be fine?
I think all technology, including AI, takes some jobs away, but creates more opportunities for different kinds of jobs. And to the extent that machines start doing jobs, maybe that are easier jobs, that are less thinking kind of jobs, that challenges humans to basically move into more advanced jobs. And there's always going to be jobs to make the machines into the AI, and that's not easy. So again, that's innovation right there, and I think that's a good thing.
Is there anything about intellectual property litigation you want to share that business owners should know?
There's one trend that's very widespread these days, which is patent litigation, which is it's typically very, very expensive. And if you're a smaller company, even if a big company is violating your patents and it's worth a lot of money to go after them, it's not cost effective to do it just because of the expense of how much it takes to do a patent case. But what we have now is the rise of the litigation funders. There's these companies out there that have a lot of money, and they'll spend it on the right kind of cases if they feel like they have a good chance of winning. And they will now basically pay for the lawyers and for all the costs of doing a litigation in exchange for some percentage of the recovery, if there is any. So it's kind of a more advanced form of a contingent case that we're dealing with now in the litigation funding world.
Interesting. And what is this organization called that can help some of these business owners?
Well, they're called litigation funders, but they're actually companies usually based out of places that you think of with a lot of money, like London and Chicago and New York, and they're bank type places.
Oh, okay.
And they have billions and billions of dollars. Some of them are publicly trading, and they're getting into this into the world of litigation funding. It doesn't even have to be a patent case. It could be a real estate case or a contract case. But now they're getting really heavily into intellectual property cases.
So this would be an option for like a smaller business that can't really afford to go up against the big conglomerate or corporation.
Yeah, that's what people are doing now. They're teaming up with litigation funders. In fact, it was funny, a couple of months ago, I was sitting at home on a Sunday, and my 80-year-old mom, who lives in Texas and is not a lawyer or anything, she called me up and she said, "Oh, you should watch 60 Minutes tonight, because they're going to do a thing on litigation funding. You really need to watch that." So I did. So it's in the mainstream now. And they were saying how
I need to watch this.
Kind of the dark side of litigation funding, because they'll help you and they'll make your case be real. That can happen, but they will take a good chunk out of your recovery and if you win. So 60 Minutes was saying, well, is this really ethical, and are you taking too much kind of thing? But you can debate that for a long time.
Yeah, you can, because otherwise maybe the case wouldn't happen. Very interesting. I know we kind of jumped from, websites to company names to medical devices to shoes, but all these
Yeah.
things are, how our economy keeps going and people keep innovating. So it's important that they understand how to protect their ideas and creativity.
Yeah, and I hope that your listeners kind of get some ideas from this and maybe go find a good lawyer to help them protect some of the ideas and product names and expressions that they should be protecting.
At what point should they contact you? Earlier the better, right?
That's exactly right. Because like I say, some of these things have clocks that are ticking on them. And if you wait too long, you may have had the best idea in the world, but you waited a year after you started selling it or told people about it. And neither you nor anybody else can get a patent on it. It's out in the public domain. And maybe that's good for the world. But in terms of the person who had the idea, that's not the outcome that they wanted. And they could have possibly saved themselves from that really bad worst case scenario if they had talked to a good lawyer in time.
Right. And how would so if someone needs to contact you, they call your office, or how do they get in touch with you?
Yeah, we have a website. People can go to our website. We have a nice domain name, which we're protecting. It's called patentlaw.us.
Oh, there you
And
go.
there's all kinds of links on there. They can contact me or lots of other attorneys that can help.
Patentlaw.us.
Yep.
Very nice.
That's right.
Okay, well, I enjoyed speaking with you today.
Likewise.
It was very nice. I hope
People about intellectual property. There's a severe lack of information about that out there, I think.
No, I know. I would love to do this again, and maybe with like a specific case we could discuss. It's fascinating. I mean, I know limited about it, even though I have an engineering degree and a law degree. I didn't go into intellectual property law, obviously, but it's fascinating. So
Yeah.
I appreciate you and taking the time today.
You're welcome.
If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Megan McNulty.